to kind of go back and take a slightly different look. I think the core problem that underlies the reason we've gotten where we are is that you don't have a check and balance system that actually works at the WTO. The fact that the appellate body may get certain decisions wrong or certain issues wrong and certain decisions from the point of view of the membership shouldn't be surprising. There's nothing infallible about being a member of the appellate body. But because the system was new in the year around and the appellate body part was added late, there are certain checks and balances that are in the agreement that in fact have never been used, and so one would have to say are not usable. And again, that probably flows from the consensus base. So if there is an error from the point of view of the membership, you basically can't get it corrected. That has led to a number of things over the years, the last 30 years. I would say that a huge number of countries in Geneva have indicated that they know that they are litigating issues that were never agreed to by their trading partners. So they have permitted the change that Bruce laid out in terms of filling gaps, et cetera, to lead them to basically abandon the negotiation function in lieu of trying to get something for free through litigation that they know their trading partners haven't done. So you have that issue that undergirds the kind of overriding problem. Now, whether you agree with the United States or disagree with the United States in terms of the issues it's raised, what is clear, at least as long as this administration is in power, is that you will not get a functioning appellate body until those issues are addressed. The issue in Geneva for the United States is largely the European Union and those who support the European Union's position that the agreement is more than what it says it is. It is not simply a means to facilitate resolution of disputes amongst members, but is rather a full court and intended to permit the creation of obligations and rights that don't exist. So if you look at what Ambassador Walker has attempted to do as a facilitator, it has been to listen to the other members identify what they would be willing to consider to address the United States. And if you look at it, basically none of the things that they're willing to do address the U.S. problems. If you have the rule in the DSU is actually that disputes are supposed to, on appeal is supposed to be done in 60 days, but can be extended to 90 days. So the concept that 90 days is a starting point tells you you're already sliding 30 days. But the fact that is very clear that is the obligation of the appellate body, and that has been ignored in about 85% of the cases since 2011, tells you that just saying again, oh, by the way, you're supposed to do these things in 90 days doesn't really get an answer to the solution. There is no enforceability. It's kind of strange to talk about enforceability for a reviewing body, but at the end of the day, the U.S. concerns are largely about enforceability on the procedural aspects. Originally, the way the rules were laid out, you should not have had a problem with needing appellate body members whose terms had expired to continue. The reason that you need them to continue, and the reason that the appellate body is perceived it needs them to continue, is the fact that disputes are not being handled in 60 to 90 days. They were required to give at least 90 days notice before leaving. That hasn't proved to be true, and of course there's some who can't stay on because of infirmities or death or other things. But there has not been, in my view, from the rest of the membership, a recognition that unless you deal with taking the rules which are clear on their face in most cases and making them enforceable, you won't get anywhere. Now there's some where the enforceability could be as simple as permitting the parties to a dispute to require certain paragraphs to be deleted from the decision. Right? That would be true in the case of where they're dealing with municipal law at the appellate body level, and that's an issue of fact which shouldn't be reviewable there. It would be true if they're dealing with issues that haven't been raised by either party. Why should the appellate body report have 10, 20, 30, 40 paragraphs dealing with issues that nobody raised and nobody briefed? And it tells you that's not. So there are some easy solutions that haven't been suggested by the membership. On the issue of overreach, which I agree with Bruce is kind of the core issue that has been there. It's actually been there since before 2000. Remember that the Trade Act of 2002, Congress required a report from the Commerce Department of the overreach problem and what to be done about it in terms of trade remedies, because there were already concerns in the dump, countervail, and safeguard area by 2002. You actually looked at the first concern raised by a member about overreach. It occurred in 1997 from Costa Rica, followed by 1998 with Mexico, followed by 1999 with Canada. The United States raised its first concern in 2000 in terms of a formal discussion. That issue has two elements. What do you do about it? And at the moment, that is probably where there's actually a need for a general counsel definitive interpretation of the term, what does it mean not to create rights or obligations that are not in the agreements. And the United States and Europe have diametrically opposed views on that. If you don't get clarification, there's nothing you can do on overreach that will solve the U.S. problem. The second aspect is, from the United States perspective, I believe, there is a concern about the dozens of cases that have gone on already where there are selected issues where overreach is a problem. Nothing has been said about what do you do in terms of going back to deal with those issues. How does that get addressed? Now, good news for all of you is if you look at my new blog, you'll see an 11.4 posting where I kind of give my suggestions as to how you can deal with all of those issues. And I will leave it there.
Thank you very much. It's a pleasure to be here. I'm going to just comment at the beginning. I noticed your reference to the songs. I would only ask that you consider, at least for this morning, adding to your playlist, You Don't Know What You Got Until It's Gone. Because I think that's the day, that's the moment that we are in. I think, again, it's been pretty well laid out what the United States hoped for, and I would argue what we've gotten, which is a binding dispute settlement system. And I think the real question before everybody is, are we going to be happier when we have now taken down a binding dispute settlement system and think about what it gets replaced with? Because I think what you're seeing right now is what it gets replaced with, which is the law of the jungle, if you will, everybody putting on tariffs as they want and then retaliating to those tariffs with their own tariffs of their own. And fundamentally what you're creating is chaos. And I think it's pretty clear that as you look across what's happening globally in the economy, chaos has a huge drag on the economic growth of everybody. So again, I just do think it's worth thinking about. I thought I would just add a little bit to what's already been said, and we'll try not to repeat it because I am certainly in agreement with an awful lot of what is said. But to me, part of the reason why we've gotten where we are is that the system just did not turn out as it was expected. And when I say the system, I really do mean the appellate system. The notion when the appellate body was added to the system, and again, I would certainly agree with Terry, this was sort of a last-minute addition to the DSU rules, because the United States, the European Union, I think Canada and others realized, okay, now that we're going to go to a binding dispute settlement system, what are we going to do if a panel just really gets it wrong, goes rogue, makes a decision in some way, based on whatever, anti-American sentiment or something else. So the idea was you did need to have this second review system, this appellate system, to correct for those rogue panels, and also, I think, to bring some notion of consistency across decisions if the same exact legal text was under consideration without it becoming overly ossified. So again, the idea was that appeals would be rare, and that they would be limited to just a few legal questions. How has it turned out? 70% of all panel decisions have been subject to an appeal. And if you look over the last 2 years, the average appeal has 15 claims in it. So these are not rare, and they're not limited to narrow issues of law. And I think that's a lot of what has been, what has raised a lot of the issues. I think the third thing that I think should not go unnoticed, that was not expected at the time, is that the parties in these cases would be largely private lawyer representations. Again, so it used to be in the old GATT days that everybody that appeared before a panel was an actual diplomat from the country before them. Now you see almost entirely private lawyers hired, by countries to represent them. But what that has meant is, A, the submissions are much, much longer. There's way more claims being raised. The average submission is running into hundreds of pages. And there's a lot more litigation over all of these procedural issues. I mean, the issue that Bruce is raising over this issue of what's exactly in the 4 square letters of the request for consultations, this is a very lawyer-driven issue of, does the panel have jurisdiction, and is there jurisdictional questions? So this again was not anticipated, I think, when the system was created. And I think the fourth thing from the United States' perspective that was not expected is we didn't expect to be sued very much. I mean, if you read all of the sort of history of this, the whole discussions about why did we want this binding dispute settlement system, again, you don't know what you got till it's gone. We were the drivers for this system. Why? Because our negotiators were extremely frustrated that throughout the 80s and early 90s, we could not get satisfaction from GATT procedures because the key issues that we wanted to win on, the panel would be blocked and never allowed to exist in the first place, or if we won, the losing side would block the adoption of that panel report. So there was tremendous frustration in the 80s and 90s that the rules didn't mean very much because of this ability to block a panel. So we were the ones that wanted this binding dispute settlement system because the perception was the US is the most open market in the world. We have the most transparent set of rules. We have a completely consistent system with the WTO rules. We've got nothing to lose and everything to gain by bringing these cases. What's happened? The United States has been a complainant, meaning bringing an affirmative case in 124 complaints, but we've been a respondent in 155. So again, we have been more on the receiving end of complaints than we have been affirmatively. Now, again, in the, don't know what you got until it's gone, think about what's come of that. Of the cases that we have brought, again, the complaining cases that we've brought, we've won 91% of them. So again, if you think about, has the system delivered for the United States, in many ways the answer is unequivocal, yes. Then when you look on the cases that are brought against us, where we're on the defensive, we've lost 89% of those. So again, I understand, but this is clearly the system sort of not working out the way it was planned. To me, the other thing that has clearly happened is in the early days of this whole system, there was a tremendous emphasis on that notion of the system is supposed to provide stability and predictability. And I would certainly agree with some of what Bruce and Terry were effectively saying, that unfortunately that strong emphasis on stability and predictability has arguably led to some ossification of the decisions, where things that happen then get close to set in stone, and it does become extremely hard to turn it around. I'm not going to go back over exactly where we are in terms of what the solutions are, other than to say that I would at least disagree to some degree with Terry about how close these Walker principles that have been put together by Ambassador Walker come to meeting the United States' concerns, because I personally believe that they have gone a very, very long way to meeting the United States' concerns. And I'll only close this really opening session to say, that my sense is that there is tremendous frustration in Geneva. That yes, the United States has done a very good job, and again, very specifically and very fulsomely laying out its concerns. And again, there's very specific dispute settlement body cases, again, Rule 15, clearly there are concerns about holdovers clearly laid out. The 90-day issue, look at the June 22nd, 2018 DSB, etc. I mean, I can go through each one of them, where the first time the United States raises these concerns, they do put out 10, 15, 20-page statement in their DSB statement about what is the nature of the concern. So I don't think there can be any accusation that the United States has not clearly laid them out. The problem in Geneva is the United States has been not engaged at all in what do we actually do to fix them. So what is the United States saying in Geneva? Because I would say everyone is very frustrated. Okay, you're great at pointing out the problem and creating chaos and blowing up the system, but where are you when it comes to coming up with some solutions and some answers? And what the United States is saying right now in Geneva is three things. One, they're saying, we're not even going to start conversing on the issue of how to solve these problems until we have gotten to the bottom of why did the appellate body feel entitled to depart from the rules in the first place. Until we have an answer to the why question, no discussion. And I will be honest, my reaction to the United States on this is, what difference does it make? Even if you have an answer to why did the appellate body feel that they couldn't get its decision done in 90 days, why does that change the outcome of the fact that what you want fixed is getting appeals back to being 90 days? I mean, does really understanding that in this instance, the appellate body couldn't do it in 90 days because, whatever, a lawyer got sick, a translator was on vacation, whatever it was, does that actually change the fact that it needs to be fixed and we need to start talking about the fix? The second thing that the United States says is the reason we're not engaging in any of this discussion is we don't want anything. We don't want any changes to the rules. We just want to go back to the rules as written in 1995. We just want to go back there. The problem is, in Geneva, the notion is, okay, fine, even if you accept that, there still has to be a process by which you get there. I mean, okay, fine, if you let's say everybody agrees we want to go back to the 1995 rules, you still, United States, have to engage in how does one get from here to there. The third thing that is clearly being said in Geneva is that the United States is not prepared to engage in any of these discussions unless and until it hears from a number of members, and I would say very specifically that is pointed at the European Union, that the European Union agrees and shares the United States' concern that the appellate body has gone awry. And until recently, I think the European Union had fundamentally not been saying that. I mean, most of what the European Union had been saying is, we do not share the United States' concerns, but we are nonetheless agreeing to work on this process. We've put forward our proposals. We have all of these suggestions. The European Union, Canada, others, lots of others have put together suggestions. But for the United States, they've come with this kind of sense of, but we don't share your concerns. We're just doing it to fix the system, or we're just doing it because we believe in a two-stage binding dispute settlement system. That, I think, there is now, I think, a considerable change. And I think around this Walker process, there has been an increasingly willingness on the part of many members, and I think even within the European Union, to say, we agree that these kind of principles that Walker is laying out are in fact necessary to course correct, are in fact needed to bring the appellate body back to, sort of within the lanes that it is supposed to operate. So at least I am cautiously optimistic, and again, I do have some specific ideas on how you then get from where we are now, what is exactly the plan moving forward. I have my own thoughts on what that plan is and would be happy in response to questions or others to go through those details.
Thank you very much. Thank you, Ken and Stacy, for the invitation to be here today. Let me start maybe by making a few linkages that go a little bit beyond the AB at the WTO. And I would reiterate the urgent need for reform and improvements at the WTO, and not just in the area of the AB. I think more generally, as WTO members, we need to up our game with respect to all of the three pillars of the WTO. And so, we need to improve the whole notification area in terms of frequency and completeness and accuracy and so on, recognizing that transparency is fundamental to making the system work. It's fundamental to facilitating dispute settlement processes. It's fundamental to facilitating negotiations, the other two pillars of the WTO. And on the negotiations area, we need to remember as members that narrow and defensive approaches there have not taken to the extreme and to excess don't serve us well there as well. And of course, relating to this whole subject, we as members need to talk more about what the rules mean, and we can't abdicate that role simply to the appellate body. And two subpoints related to that, I would say, is that the AB will function best, can function best, when members exercise restraint in litigation. And also, the AB will be most effective when we as members are prepared to engage together and talk about the meaning of the rules. So, in all of these matters, Canada has some sympathy with the frustrations expressed by the United States and about the current state of play. But we should not, as was just mentioned, we should not lose sight of the benefits that we gain from having a functional WTO undergirded by binding DS. And that related to that, I would say that the body of law that has been created in the WTO has, among other things, has helped to maximize predictability in international commerce. The U.S., as much as anyone or more, knows how important this is to the business community, and so it's hard to see, in terms of the prospective developments in December vis-a-vis the AB, how that's going to be positive for U.S. business confidence in any context. A couple of things, just in terms of what Canada has done recently. 13 months ago, Canada convened what's known as the Ottawa Group. It's a group of about a dozen like-minded countries, WTO members. They've met 4 times over the last year or so, and consistent with what I said just a few minutes ago, has focused very much on all of the 3 pillars of the WTO, and including the reality that the AB is one of several areas that needs work. So they've drilled down, they are drilling down with 4 countries taking the lead on 4 specific areas of committee work, which is actually, and that particular work is actually open to all members who want to engage. Norway has done some work on the development dimensions of WTO reform, and I think that the work of the Ottawa Group is very much also supportive of the Walker process and is trying to figure out ways to support that. They've also tried to facilitate ongoing negotiations by hooking up fisheries negotiators with experts in that area and trying to facilitate progress there. The other thing, as was mentioned, Canada and the EU have entered into an interim arbitration appeal mechanism, which relies on the existing DSU mechanism, Article 25. It's aimed to preserve our WTO rights until the AB impasse is resolved. The objective, of course, is that the predictability and stability that results from binding DS would be maintained in any bilateral disputes that Canada and the EU might have. Frankly, this we see as the best option, short of a functional appellate body. That said, we will certainly continue to work with members toward a durable solution to the AB and to try to improve the DS more generally. Jennifer mentioned, the U.S.'s batting average at the WTO. I think various studies have indicated that it is, in terms of the plaintiff, is better than the global average in terms of success. As defendant is also better than the global average in terms of defending. So there's a lot there. I think, again, relating to the business confidence and the stability of the system that's resulted from that. The other thing is that, we couple of years ago, we passed in this building actually at a WITA event, the 70th anniversary of the founding of the GATT. It should be mentioned that, you know, that founding and all of the progress that accrued in the decades that followed happened not only with U.S. concurrence, but with a lot of U.S. leadership as part of that process. Canada, as I said, we have some sympathy for the U.S. position, but we also call on the U.S. to engage more and to be more specific in terms of their concerns and also the way forward that they think in terms of the things that need to change. Some of them are obviously much easier than others in terms of some of the procedural things perhaps than the other issues that were mentioned here. But we would disagree with the view that the right thing to do at this time is to let the AV, the appellate body, fall into dysfunction. You know, whether and when and where and how the AV has aired or may have aired is certainly in the eye of the beholder, but that is a discussion that is going to need everybody stepping up to the bar and engaging in a productive and constructive way. I think I'll leave it there for now and let Stacy take us into some questions.